Hi, this is Kaushik Ranchod from the Ranchod Law Group, and today I'm going to be talking about family-based green cards. We're going to talk about the different processes, processing times, and which way to proceed, and what you want to look out for. So you'll want to watch this video because this can be a very complex process. You'll want to see what you want to make sure you want to avoid and what category you may fall into to determine your processing times. So let's start off with the big distinction here to determine whether or not you're going to have a longer wait or not, and that is by evaluating first if you are an immediate relative. So an immediate relative is if you are a spouse of a U.S. citizen, and if you want details about that, check out my videos on that. We're not going to talk about spouses in this video. We're going to talk about other family members. And in another immediate relative category are parents, if the child is 21 and filing for you. And so in this situation, it's really important to note that you got to be 21 as a U.S. citizen child of the parent. It's if you're younger than that, then you're not an immediate relative and you're not able to file. So the third category is unmarried people who are under the age of 21 who have at least one U.S. citizen parent. So if you're in one of these categories, the nice thing is that you don't have to wait in the way that I like to look at this is, and the easy way to explain it to you is that you don't have to wait in a line. There's no numerical limitation, if you will, to be able to file both the I-130 and the second step of the process, the green card application, the 485 if you're in the United States, or the green card process. You can go immediately to filing those both of those together. So there's no wait. Now, if you're not an immediate relative, then you have these longer wait. I'm going to talk about that and the different types of categories where you can bring a family member over, who you can bring over, and we will dive into that now. So there's 4 different main categories that I'm going to talk about. The first category is if you are filing and you're a U.S. citizen parent and you're filing for your child and they're married. So that's the first preference, and that actually has quite a long wait time, believe it or not. And that's the first preference. Now, the reason that there is a long wait is because there's numerical limitations on each of these categories on how many numbers can be given out for each of these immigrant visas or green cards. So that's why there's a wait. Depending upon how long it takes for that number to get used up and how many numbers there are, how many people are applying, determines the wait time primarily. Now I'm going to go and talk about the second preference. So the second preference is 2A and 2B are the 2 categories. 2A is where you're spouses and children of a lawful permanent resident, and in this situation, you are under 21. And 2B is if you're unmarried and you're 21 or older. So that's the second preference broken down in 2A, 2B. And then there's third preference, and third preference are if you're married and you have at least one U.S. citizen parent. And then there's fourth preference, and that's where you have a brother or sister who's 21 or older and is able to file a petition for you. And in that situation, they're able to file an I-130 petition for you based off of the fact that they're a U.S. citizen and they're your brother or sister. So those are the 4 main categories that are not immediate relatives, but you're able to file start the immigrant visa process, start off with the I-130, or maybe even file a 1-step if the priority date is current. So what does it mean if the priority date is current? So if the priority date is current, that means that you can file both the I-130 and the 485 at the same time if you're in the United States, or do the green card process if you're abroad. Now, what's important to note here is you got to look at the visa bulletin, and current means that on the visa bulletin it'll have the notation of C there, and that means that the priority date is current. Otherwise, it'll have a date, and that date will show you the time or the applications that they were looking at when those applications were submitted. the date that they were submitted and what applications they're actually currently looking at. So let me explain that. For instance, if it says November 1st, 2015, that means that they're looking at applications from 2015 right now. So that gives you a sense of when your application would be viewed. Now, what's even more confusing about this, though, is sometimes for months, the dates won't move, and then they can also move very quickly. So my recommendation is just to continue to monitor the visa bulletin. All right, now I'm going to talk about the parental green card process, and we're going to deep dive into that. So the parental green card process, that is a situation where you want to file for your parent. So they're either abroad and you want to bring them over, or they're already in the United States and you want to file for them. So in this situation, as I mentioned earlier, they are an immediate relative. In this situation, if you are 21 or over, you can go ahead and file the I-130 petition for them. And if they're in the United States, you can also file the 485. You have to demonstrate that you're going to be able to financially support them with the affidavit of support form. And you can also file work authorization and a travel document as well simultaneously with the parental green card application. What's important to note is that they've had to have entered with inspection. So that means they had to have entered not without a visa, but they were inspected at the port of entry coming in, and they were given an I-94. They have an I-94 number to be able to demonstrate that they have lawful entry, and their passport was also stamped. So that's proof of lawful entry. Otherwise, you're not able to file for an adjustment of status. So in that situation, we're assuming that they entered with inspection. Now they're here. Another important pitfall, an area that I want you to be aware of, is that your parents should not have the intent to come in and stay in the United States permanently. The reason for that is because it depends on what type of visa that they're coming in. But I'm assuming they're coming in on a visitor's visa. So if they come in on a visitor's visa, then this is a situation where you want to be very careful that your parent is not coming in to wanting to stay in the United States permanently, because what the appropriate procedure for that would be is an immigrant visa, consular processing. So what if they come in, they enter, and then later on change their mind? Well, in that situation, then it's different. The USCIS will look at the timing of when they changed their mind and their actions to evaluate whether or not there was actual visa fraud or not. So previously there was something called the 30, 60, 90-day rule, where they would evaluate the timing based off of that rule. Now there's a new 90-day rule to evaluate the timing. And that's one primary factor. It's also, evidence of other actions that your parent took prior to coming. And so those are some of the factors in evaluating that. Basically, bottom line is, if you have the intent to do the immigrant visa process, not the adjustment of status process. And if you have questions about this, feel free to contact us and we can talk about that further. Now, in all of these applications, it's really important to note that you have the burden of proof in demonstrating that your parent is able to come here or stay in the United States. So that means that you have to show the relationship between both of you, and that's done primarily through the birth certificate. Now, why this is really important is because a lot of times parents don't have the appropriate documentation or don't have a birth certificate, and in that situation you have to provide secondary evidence. So you want to make sure that you have the right secondary evidence in order to be able to demonstrate that you have the actual family relationship, because the whole application is based off of the fact you're actually the child of your parent. So that's why they're sticklers about this documentation, and they do allow you to provide secondary evidence to demonstrate that. Normally you have to demonstrate that you're not able to actually get the birth certificate and have that actual documentation showing you're not able to get it, and then you're able to provide secondary documentation as well. Another important factor here is if you have any criminal issues, that could be a grounds for inadmissibility. Also, if you're not meeting the affidavit of support requirements and income self-sufficiency requirements as of today that I'm giving you talking in this video. That's an issue that may change in the future, the self-sufficiency requirements. However, that's important. They want to see that your parent's not going to take public benefits, that they haven't taken public benefits. You really want to make sure with the self-sufficiency application that you provide not just the information, but also documentation that they're asking for as well, because the documentation is equally important as the information on the form, because they're looking at that to corroborate what you're putting on the form. So with the adjustment of status process, you are filing with your local service center in the United States, and you, as I mentioned, you can file what's called a one-step, the I-130 and the 485 together, and then at the there's going to be a biometrics process. After that, that's basically a background check, making sure that there's not criminal issues, or if they are, those criminal issues are going to come up and you're going to have to address them. And then a month before the interview, you're going to be scheduled for an interview. Typically, right now it's happening much faster because of the fact that they were backlogged with all of these interviews, but that's always changing. In general, it's about a month. Right now, it's like happening, we're seeing it as fast as like 2 weeks, but typically on average, it's about a month. So that's what I would expect. Then both of you need to go to the interview. If you don't, the application could be denied. So that's really important. Both of you need to go to the interview if it's in the United States. Now, if it's not in the United States, we're going to switch gears here to consular processing. What if your parent is outside of the United States? Well, in that situation, you would do what's called consular processing. You file the I-130 here with the local service center, depending upon where you live. You can check that out at USCIS.gov. And then you wait for your I-130 to be petitioned to be approved. Now, once it's approved, then you get to move on to the National Visa Center process. That's where they're going to ask for the income, self-sufficiency information. You need to also demonstrate that you are going to be able to sponsor them in the terms of that you have the income requirements necessary so that they are not going to be a public charge. That information is provided. And then that's where they also ask for typically they ask for the birth certificates, and you have to complete the form DS-260 as of today and other documentation. So you submit all of that documentation, then National Visa Center is very picky, so they may come back and say, well, we don't like this, and then we want more, address these issues. So then after the National Visa Center is satisfied, then they're going to coordinate with the embassy to set up a date for you to have the interview. And then you'll finally have the interview. Now, different to the adjustment of status, the U.S. citizen petitioner does not need to be present at the interview. So as a parent, you go to the interview. The two main things that there's three main things that they're going to evaluate at the interview: whether or not you're admissible, whether or not you meet the self-sufficiency and affidavit of support requirements, and whether or not you can demonstrate that you actually have the real relationship through the birth certificate. Those are the three main factors. And of course, everything else needs to be accurately completed. Otherwise, that could be a reason for denial or delay depending upon how it was completed. So all of that's going to be evaluated. If everything goes well, then your parent will come in as a lawful permanent resident. So I know with all of these changes that have been happening, things can be very confusing. Immigration law changes so fast and frequently, so I invite you to contact us if you have questions. Please like this button. I try to put a lot of effort into making a great video for you, so I'd love to get your like or feedback. And thank you so much for tuning in. You're amazing for wanting to better yourself and better your family. And we will see you next time. Bye.